Warm welcome from my side to our second webinar in our SeedFast series designed to help you navigate the mechanics of a financing round. In today's session, we'll dive into the different types of capital increases and the key factors to consider when selecting the right one for your company. Over the next few weeks, we'll break down the entire financing process, covering the key steps, the legal agreements, and the closing procedures, all to give you the knowledge and tools that you need to structure your upcoming financing round. Today, Dominik will walk you through the various types of capital increases, highlighting their advantages, disadvantages, and helping you to understand which one might be the best fit for your specific situation. Dominik, I'll hand over to you and enjoy the session.
Thank you very much for the introduction, Alain. As you mentioned in your introduction, there are different types of capital increases, and they all distinguish with different characteristics, the suitability of the companies that make use of them, their advantages, and obviously always where there's light, there's also shadow, which means they have disadvantages as well. Let's begin with the ordinary capital increase. Exactly, which is actually the most flexible form of capital increases, and that is also suitable for short-term capital increases in particular. So what are the characteristics of the ordinary capital increase? First of all, they require an AGM resolution, and this is a little spoiler, but all of the capital increases require a resolution by the shareholders. So just to mention this before we dive also into the other forms of capital increases. The AGM resolution for an ordinary capital increase is only valid for 6 months, which means that the company needs to push a little bit on the speed to close their capital increase, because after those 6 months, if you do not have any investors or if you do not raise the entire amount of the capital increase, you have to get a new resolution from the shareholders. On the other hand, there is no limitation in the amount, and we will also see this in context of the other forms of capital increases that require a limitation of the amount. So the ordinary capital increase is the only form of capital increase, according to the Swiss law, that allows a capital increase without limitation of the amount. And then the amendment of the Articles of Association is only after the payment of the capital, which means at the very end of the process. This also gives some flexibility, as the Articles of Association only need to be changed once in the whole process of the ordinary capital increase, whereas still 2 notarizations are necessary, one of the AGM resolution and then the second one after closing the round. So what companies are ordinary capital increases suitable for? A specialty of the ordinary capital increase is that it is an advantage if you already know the investors, the future investors that will participate in that current round, because you only have a time limit of 6 months. So usually companies make use of the ordinary capital increase if they already know their investors and if the new investors also have given their soft commitments to the financial round. It doesn't need to be the formal commitment in the subscription form yet, because the subscription form also needs to refer to the date of the AGM resolution, so you cannot fill this in too much time ahead of the annual general meeting or the extraordinary general meeting. And also, the ordinary capital increase is the usual form of the capital increase. So it's actually the most standardized one, if you want, for regular capital increases, and therefore also the name ordinary capital increase. So what are the advantages of the ordinary capital increase? It's very fast. The AGM takes the resolution and you can onboard the investors right after that and then close the financial round. And it's also very flexible in terms of the amount. As I said before, it's the only form of capital increase according to Swiss law that does not have a legal limit of the amount you can raise. And then another advantage is that it's flexible in terms of types of payment. So there are different types of contribution. There's the contribution in cash, where the investors pay money, cash, into a capital deposit account with a Swiss bank. But then there's also the possibility to offset loans. So in particular, convertible loans. But then it's also suitable for contribution in kind. For example, if you want to add IP, if you want to invest in form of real estate, etc., etc. So this type of capital increase gives you a lot of flexibility. On the other hand, there's also disadvantages. One that I mentioned already, the resolution of the AGM expires 6 months after it's been taken by the shareholders, which means you need to speed up the whole process. And this also requires that you're already at least in negotiation with the shareholders, as I mentioned before. Now, the second form of capital increase that the Swiss law knows is the capital band. Actually, the capital band was only introduced 2 years ago with the revision of the stock corporate law, or the Swiss Code of Obligation, and it replaces the authorized capital increase. Yes, it enables a company to raise and also decrease their capital in a flexible manner within a time frame of maximum 5 years. And it's that form of capital increase that actually provides the board of directors with the largest extent of flexibility and autonomy. First of all, also here, it requires a resolution by the shareholders and an amendment of the Articles of Association. So they need to be changed right in the process of taking that resolution. That resolution is, as I mentioned before, valid for maximum 5 years. So it's a large time span in which the board of directors can increase or also decrease the capital of the company. There are, in contrast to the ordinary capital increase, limits in the amount that can be raised or increased by maximum. So this is maximum 50% of the previous share capital, which means if a company has, for example, 100,000 Swiss francs of share capital, they can increase the capital to a maximum amount of 150,000 Swiss francs by making use of the capital band. There's also a lower limit of the capital band, which is the minimum share capital amount of a stock corporate in Switzerland, which is 100,000 Swiss francs. So if you raise 25,000 Swiss francs, for example, and you want to decrease again, you cannot go below those 100,000 Swiss francs. Now, one of the particularities of the capital band is that the capital increase also requires a resolution of the board of directors of the company, which means that the company or the board of directors decides to implement the capital increase according to the authorization they have been granted by the shareholders. It's a very specific resolution, which means the board of directors needs to decide on which amount in particular they want to increase, how many shares they want to issue, at which issue price. And this all needs to be documented in detail in the minutes of that board meeting and also then signed in a formal, correct way by the board members, which is either a handwritten signature or a qualified electronic signature. And this document then also is relevant for the last step in the process when the financial round is being closed together with the notary public. And then the last point is the implementation of the BOD in accordance, obviously also within the limits of what has been granted and defined in the Articles of Association. And the capital band is in particular suitable for companies that do not know the exact timing of when they want to raise the funds and also do not know their investors yet. On the other hand, it enables them to increase the capital at very short notice, as soon as they identify a suitable investor or as soon as they have the financial or economic need for additional capital. The advantages are a very high flexibility and autonomy of the board of directors. This means they do not need to convoke a general meeting to get the authorization because they already have it. This helps them save a lot of time. And another advantage is that they can raise the capital at very short notice within those 5 years. And also, it's very flexible in terms of the capital itself. So the capital can be increased in several steps if needed, but it can also be decreased if there is additional cash that can be paid back to the shareholders. Yeah, and then where you can find advantages, you can always also find disadvantages. One of the disadvantages of the capital band is that the amount to increase the capital is limited to 50% of the existing capital. So this gives a limit in the funds you can raise. So if you need to raise more than 50% of the existing capital, the capital band is obviously not the right instrument. And then also what you need to take into consideration if you make use of the capital band and you increase the capital in several steps. After each of those steps, the articles of association need to be updated together with the notary public and then also filed with the commercial register. And then we have the third and last type of capital increase according to Swiss law. That's the conditional capital increase or the contingent capital increase, as the Code of Obligation states this. This is in particular the idea of the conditional capital increase is to either grant options to employees in context of an employee stock option program or to issue convertible loans to external investors. So also here, it's required to have an AGM resolution, and the articles of association also need to be amended after that AGM resolution together with the notary public. And the resolution, in contrast to the other two forms of capital increase that we saw, is not limited time-wise. So you can also execute those options or convert a loan into share capital after 5 years or after 8 years. There's no time limit. However, there's a capital limit. Also here, like the capital band, the capital can only be increased by maximum 50% of the existing share capital. One of the particularities is that nobody needs to decide to formally increase the capital. So when we have a capital band, as I mentioned before, it's the board of directors that need to take that resolution to increase the capital. In the case of a conditional capital increase, the capital is automatically increased once the options are executed or the convertible loan is being converted into shares. Also, one of the characteristics is a very limited application of the conditional capital. So it's either made for stock option programs of employees or of convertible loans, but there is no other form of capital contribution or of allocating new shareholders. It's very suitable, obviously, for companies that have an employee participation program or that want to issue convertible loans. And a convertible loan is a very handy financing instrument, in particular for startups, as there are no formalities to be followed immediately when you take up that loan or issue that loan and do the funding. So that's also one of the advantages. It's very flexible at that very moment when issuing the convertible loan or receiving the funds. You also do not need to have the capital, the investment paid to capital deposit account, which means the capital invested is immediately available to the company once it's been paid in by the shareholders or by the investors, in contrast to the other forms of capital increase where cash contributions are being paid to a capital deposit account. So this gives the company a lot of flexibility, and they can actually use the funds invested at the very moment they arrive on their banking account. And then one of the advantages of employee participation program is obviously to incentivize employees as they become also co-owners of the company. Then there are also disadvantages again. So it requires a statutory basis before you can grant convertible loans. We will elaborate on this in one of the upcoming webinars and also tell you the differences between issuing a convertible loan with a statutory basis versus having no statutory basis. But let's do this in another session. One of the disadvantages is that there are very high formal requirements once the convertible loan will be converted into shares, one of them being an audit obligation, which means an auditor needs to examine the whole process of the capital increase and then state that it's in line with legal requirements and also the requirements of the Articles of Association. But we will also dive deeper into this in one of the upcoming sessions. Yes, and then the conclusion and summary. Actually, as we said at the beginning, or as you have seen in the course of those slides, that all form of capital increases have their particularities, all have their advantages and disadvantages, and it's subject to an individual assessment on which form of capital increase fits the best to the current situation of the company.
Thank you, Dominik. And maybe I have two questions, or one comment and one question. The first comment, the capital band, maybe we go back, is very often used in financing rounds when you do staged investments. Let's say the investor says, I'm going to provide you with certain money based on the achievement of certain milestones. So the money is not paid directly via an ordinary capital increase, but maybe one ordinary capital increase. And then there's a capital band, which provides that the board of directors may issue further capital upon certain limits. That's quite often used in that. And one question that always comes up, you mentioned that we're going to talk about it later, but maybe some pre-discussions about the publicity of the investor when you convert convertible loans, if you have conditional capital or if there's a conditional capital increase, and versus if you don't. Can you talk about this a little bit, maybe, or what your experiences are?
Yes, my experiences is that you do not pay attention at all to the statutory basis of your capital increase, your conditional capital increase. All the investors will appear in the Articles of Association of the company. Now, as it is, not a surprise, in Switzerland, we have 26 different cantonal commercial registers, and they apply sometimes a little bit different policy on how to implement this. So I have seen cantons where the investors really disappeared or never appeared in the Articles of Association. By contrast, I've also seen Articles of Association where all the investors were mentioned by name and by the amount invested, irrespective of the statutory basis.
Yeah. So I think the chances, and that's an advantage, the chances of not being mentioned in the articles is higher if you have conditional capital in your Article of Association and then enter into convertible loan agreements. Unfortunately, not many companies do this because often the argument is, I don't want to spend the notarization fee or some legal fees to have it in my articles. And then once they do the conversion, they realize, hey, some of the investors, they don't want to be public. Whether that's justified or not is a totally different question. But if they don't want to be, they have to take some quite adventurous routes to circumvent this. It's possible, but I think in the bottom line, the costs are much lower if you have the statutory basis, the conditional capital or the contingent capital, and then issue CLAs, convertible loan agreements, then do it afterwards.
I fully agree. Yeah, I think it's well brought to the point by you when you say the chances are higher when you have a statutory basis that your investors do not show. And yeah, speaking of the cost, I mean, at the beginning, investors were not aware of that at all. But I think also investors have learned. And most investors are not very keen to see their names and in particular the investment amount in articles of association, which in most cantons are also publicly available through the commercial registers. For curious people, it's always possible to download articles of association and see who has invested. And therefore, if you do not want to scare away potential investors, a company is very well advised to have a statutory basis before they raise funds with convertible loans. So that's a very important point.
I agree. By now, you should have a good understanding of the different types of capital increases and should be well prepared for our future webinars where we dive into more key aspects and particularly agreements that are involved in a financing round. Our goal with this webinar is to equip you with the knowledge and the tools you need to structure your funding round effectively and efficiently. So next up, we'll be discussing term sheets, why they matter and how they shape the total financing round. And the next webinar is going to happen on the 2nd of April. It's again on Wednesday at 11 a.m. And we are both looking forward to see you there again, and have a good day. Dominik,
thank you.
nice to see you and have a good afternoon.
Bye-bye. Have a good day.